Welcome to the Myeloma Financial Coach chapter. My name is Audrey Burton-Bethke, and I am the Myeloma Crowd Community Manager. Today we will be discussing, today is our Myeloma Financial Coach chapter, and let me share some slides to give some announcements as we begin. Let's see. So today we are joined, I don't know, my mind's not working this morning. Today we are joined by Myeloma Financial Coach Coach Diahanna Vallentine and also attorney Stewart Pope, and I will introduce both of them formally in just a moment. This meeting will be recorded and sent out to all registrants along with the slides 24 to 48 hours after the event has concluded. I would like to thank our sponsors, AbbVie, Bristol Myers Squibb, Amgen Oncology, Karyopharm Therapeutics, Adaptive Biotechnologies, Genentech Oncopeptides, and Takeda Oncology. It is now my pleasure to introduce to you Diahanna Vallentine. She is our Myeloma Financial Coach, and she is a BCPA. She specializes in financial help for multiple myeloma patients and caregivers, and as a professional financial consultant and former caregiver of her husband who was diagnosed with myeloma, Diahanna perfectly understands the financial issues facing myeloma patients. As Stewart Pope is an attorney and serves as the advocacy director of the Legal Aid Society of Louisville, Kentucky, a nonprofit public interest law firm advocating on behalf of the low-income community. Mr. Pope has worked in the housing and consumer units at Legal Aid Society, concentrating his practice in the areas of landlord-tenant law, foreclosure, and predatory lending. He has conducted trainings and seminars designed to advise low-income individuals of their rights and responsibilities as tenants, how to avoid the snares of predatory lenders, the foreclosure process, and alternatives to foreclosure. Mr. Pope has participated as a member of various task forces created to address and reduce the problem of foreclosure and vacant and abandoned properties in the community. Mr. Pope serves on the board of directors of the Continuum of Care that oversees the provision of homeless services in Jefferson County. And before coming to work for the Legal Aid Society, Mr. Pope worked as a private attorney with a practice concentrating in general civil and criminal law and as a real estate closing attorney. Mr. Pope has 2 grandchildren, 3 stepchildren, and 6 grandchildren. So today's topic is housing and rental laws for tenants with disabilities. And in this case, when we talk about disabilities, myeloma is included within that umbrella term. And I'd love to turn the time over to Diahanna to briefly explain why she chose this topic for the Myeloma Financial Coach chapter. And then in turn, she will turn the time over to Stewart to Mr. Pope for his presentation. So Diahanna, go ahead.
Hello, everyone. Thank you for joining us. It's a pleasure to introduce Stewart Pope because he has so much experience. And as all of us are aware, there's so much going on right now with eviction moratoriums and people not aware of what's going to be going on or what's happening now. And I felt it was very pertinent to bring this topic up and give you some answers to some of the things you may have questions to. I've personally spoken to several myeloma patients who are having some issues, and I thought that if they're having the issues, maybe someone else is as well. And for those of you who tune in to our monthly and sometimes in other areas, our webinars, is a lot of this information we give is not just pertinent to myeloma. It's pertinent to people with disabilities of whatever that disability is. So I would encourage you, whatever information you get from us today, share that with other people you know may be experiencing some of the same issues, and this will go a long way. So I want to introduce to you Stewart Pope. I will turn it over to you, Stewart, and thank you for joining us.
Well, thank you both for asking me to be with you today. When Diahanna asked me if I would give a presentation concerning landlord-tenant issues, I thought, sure, that'll be easy enough. I can talk about landlord-tenant stuff all day. And then as I started to prepare for it and think about it, I thought, well, it's not really so easy after all, because the law of real property, which includes landlord tenant, it includes home ownership, and real property just means land and any permanent attachments like your house or whatever. But that law is governed by state law, and it varies from state to state. So the landlord tenant law in Kentucky, where I practice, is different than the landlord tenant law in Indiana, which is just across the river, or any of the surrounding states. And it's going to be different in your state. So the challenge was, how do I come up with a presentation that will be relevant to everybody? And, decided that there's some things that are just generally true, no matter where you live, some principles of landlord tenant law. But you do, if you have an issue that comes up, you can Google it and Google it for your state, but you also have to probably Google it for the town you live in or whatever, because as I say, it varies from state to state, but it also varies by jurisdiction within the state. So if you're living in a city, the law that applies to you as a tenant might be different than what they have in the rural areas of your state. The landlord tenant law is varying. Many states and jurisdictions have adopted the Uniform Residential Landlord and Tenant Act, which applies to residential tenancies. And that's what we're going to talk about today, is residential leases and things like that, rather than commercial leases. In commercial leases, the parties are considered to have equal bargaining power, so they don't necessarily need some of the protections that the law gives to tenants. Residential tenants, don't have equal bargaining power with the landlords usually. They may have a lower income, or they're needing to rent the property, so there's not really equal bargaining power there. But many jurisdictions have adopted the Uniform Residential Landlord and Tenant Act, and there are a number of uniform laws, like you've probably heard of the Uniform Commercial Code. Every state has adopted that, and it's just, the purpose was to make doing business among the states easier, and to know what your transactions were going to be, how they would be handled from different states. So this is a uniform act, and it's intended to give some rights to tenants that they wouldn't otherwise have. Many states have enacted URLTA, and sometimes in states like Kentucky adopted it, but not for the whole state. They just said, okay, we approve it, and you can, any local jurisdiction can adopt it to apply in their city or county. So that's why I say, if you're looking to see what the law is that applies to your situation, you will have to not only look at the law of the state, but look at the law of your locality, because it could change depending on your jurisdiction. So in this discussion, we're going to focus on some of the URLTA provisions, but also general provisions that apply in most landlord tenant situations. After that, we'll also discuss the Fair Housing Act as it applies to individuals with disabilities. It applies in many other situations as well, but I think of interest to this group will be individuals with disabilities. So that's what we'll concentrate on. Okay, so the Uniform Residential Landlord and Tenant Act gives some rights to tenants that they don't often or don't always have in common law, which is the case law that all states have. It includes certain notices, like if the landlord intends to evict the tenant, they have to give them notice of the reason that they're evicting. And it's a certain notice if it's non-payment of rent. It's certain notice if it's for a material breach, like playing music too loud and disturbing the neighbors, something like that. UROTA also says that the landlord guarantees that the property is habitable, meaning fit to live in, and that it conforms to building and housing codes. So interestingly, a lot of times in the common law, there is no warranty of habitability. So in Louisville, where I live, we have UROTA. There is a warranty of habitability. If you drive 15 minutes south on Interstate 65 and get to the next county, there is no warranty of habitability. So if you rent a house or an apartment there, the landlord is not warranting that it is fit to live in. Now, if you live in a jurisdiction that doesn't have UROTA, there will be building and housing codes that landlords would have to abide by. So it's not like if you get a place that does need some kind of repairs or things that you couldn't enforce that. But you might have to look to the health department rather than looking at some other legal remedy, filing a suit against your landlord or something like that. One thing to remember, and I'd never really thought about this until a couple of weeks ago, and I was on a panel discussion with several other people talking about landlord-tenant law and the Cdc Moratorium on evictions and things like that. And there was a group of our group leading the discussion, had different backgrounds. So one of the attorneys represented landlords, but she said something that is very true and that I've learned in my practice, and I never just really put it in words. And that is the condition of the house or apartment that you are renting will never be better than the first time you inspect them. So, the landlord, and if you've got a really good landlord and they say, oh yeah, if you move in, I'll fix this and that, they may do it, but probably not. So, what you can count on is if you rent an apartment or house, that's probably the condition that it's going to be in for the entire time that you're there. And so just keep that in mind. Other things, I had a question as to what the difference between a lease and a rental agreement is. And actually, they're the same thing. And the other thing to remember about leases are that they're just contracts. So, and it's a contract where a landlord is really selling to a tenant the right to possess and live in and use a piece of property. So when you're thinking about your lease, and depending on your jurisdiction, it can be oral. They're usually written, but a lease is a contract, so all of contract law is going to apply. If there are unconscionable terms in your lease, then then a court may strike that out. So an unconscionable term might be if the lease provides that the tenant will replace the furnace if it breaks down. Well, that's, replacing the furnace, plumbing, that kind of maintenance is not a tenant responsibility. That is a landlord responsibility, and the landlord really can't contract that away. So, a court could very well find that clause unconscionable. So if a landlord, say, filed an eviction and then said, well, I'm filing the eviction because the lease says that the tenant will replace the furnace if it goes out, and they didn't, I think the court would strike that out as unconscionable and void that clause of the lease. They might not hold the whole lease invalid, but they would void that clause of the lease. Another thing that goes with a lease being a contract is that the parties have an obligation to mitigate damages. So that what that means is to do whatever they can to lessen their damages. So let's consider, for example, a case where a tenant has a year-long lease with the landlord. And, 5 or 6 months into the lease, the tenant gets a new job that's going to require them to move out of town or something like that. And so they need to break the lease 6 months early. And they go to the landlord and tell them, I've got a new job, I need to move. And the landlord says, well, okay, that's fine, but you owe me still 6 months rent for the balance of the lease, and you're going to have to pay that, or I'm going to sue you, and blah, blah, blah. Well, that's not right. And the tenant should definitely not, pay the balance of the rent in order to move out. What the landlord has to mitigate their damages. So that means that they have to use their best efforts to re-rent that property. And so if the property is only vacant for 2 months, then the tenant would only be on the line for 2 months. If the landlord re-rents the property after 2 months, then the tenant wouldn't owe the balance of the 4 months. And if the landlord doesn't make any effort to rent the property, then the tenant could argue that they don't owe anything because the landlord didn't operate in good faith as far as trying to mitigate their damages. Okay, so one question that always comes up is, what do you do when there are maintenance issues? I deal with a lot of, all of our clients are lower income and live in affordable or low cost housing usually, and they get some kind of weird maintenance issues. Like I was amazed at how many times people call because sewage is coming up in their bathtub. It just seems like it happens all the time. And so one of the major complaints that we get, or that I hear from tenants, is that landlords won't maintain the property. They've got a problem, whether it's sewage coming up in the bathroom, clogged up sinks, the furnace is out, the air conditioner's out, and the landlord won't fix it. And the tenant requests it and requests it and requests it. And the landlord just doesn't make an adequate repair. So the tenant eventually will think, well, if they don't repair it and I'm not really getting my money's worth, I'm not going to pay my rent. Withholding rent, I think, is universally not allowed. There are times in under URELTA where you can withhold a portion of the rent if you fix the problem yourself. But withholding rent is never going to be a remedy for the landlord's failure to maintain the premises. It will never be a defense in eviction court when the landlord files for non-payment of rent. So that's just never a remedy that you can use. Now, one thing, if the maintenance problem is serious, one thing you can always do is contact your local code enforcement or health department, whoever, and they will come out and do an inspection, and will cite the landlord and order them to make the repairs, hopefully. So that is really your best option in the case of a landlord who fails to maintain the premises. But withholding rent for any reason will always result in an eviction. And judges, and I think it's pretty uniform across the nation, judges will not accept that as a defense. Okay, why do landlords file evictions? Well, they file for non-payment of rent is most often the reason. And they file for material breach. That's the kind of thing where somebody's playing their music too loud, disturbing neighbors. They're taking more than their allotted number of parking spaces. Whatever, that's material breach of the lease. And under both of those things, UROTA provides for a right to cure. So in the notice period, the tenant has the right to pay the rent if they have, if they have the ability to. And if it's a material breach, if the tenant stops playing their music too loud and disturbing the neighbors within a certain period of time, then the breach will be cured and the landlord can't evict. And then the other reason that people get evicted is the lease just expires, and the tenant doesn't want to leave, and the landlord doesn't want to renew the lease for whatever reason. So they may file an eviction. So I had somebody ask me the other day if they really needed to retain an attorney if they receive an eviction notice. And the answer to that is absolutely. And I think this is universal across the country. When I talk to other legal service attorneys and participate in webinars or conferences and things with that. Eviction court, in my experience, is the least individual friendly court in the courthouse. If somebody goes into criminal court and has some minor criminal charge, they have a basic idea about how that works just from the fact that they've seen it on TV so many times, and they can quote what their rights are and all that kind of stuff. But in eviction court, people really don't know how it operates, and I think they're universally across the country set up to be favorable for landlords. They're set up to be very fast. It's an expedited process. So from the time you get your eviction notice until the time your court date is scheduled, it won't be very much time. And chances are, if you go into eviction court and you're representing yourself, if you are able to say 2 or 3 words, you will be lucky. Judgments are entered here in Jefferson County, at least pre-COVID days, in as little as 30 seconds. That's how long the case gets considered. The judge might say, tenant, did you pay your rent? And if the answer is no, they just say guilty, and that's the end of it. So you should always take an attorney with you into eviction court. You might also hear it called forcible detainer court, same thing. But you should be represented, because a lot of times what we do, even if the issue is non-payment, the object is always to keep somebody from becoming homeless. So an attorney can get you extra time to move, maybe negotiate a payment plan with the landlord if you hadn't been able to pay rent, but now you can pay it, but you can't pay it all in a lump sum. An attorney can get lots of positive outcomes for you in that situation. Now, if you can't afford an attorney, there are legal service providers all over the country. I think every county, every jurisdiction in the country has a legal service agency. Now, they might not be located in your county. They're regional, like the Legal Aid Society where I work. We serve Jefferson County, which is the most populous county in the state, and 15 counties surrounding. So, if you live in a rural area or something like that, the legal service provider may be, in the nearest big city, but they will provide legal service in your area, and they can work for you. Also, if you want to hire an attorney, if you can afford to hire an attorney, then most local bar associations will have lawyer referral services, so you can call them and they will send you to somebody who's has expertise in landlord-tenant law. So be sure to check lawyer referral service. And that applies really to any legal issue you've got. If you don't know an attorney to draft a will or whatever, you can check with the local bar association and they will give you some names of attorneys that can help you with that. One very important thing to remember, if you have a Section 8 voucher and an eviction judgment is entered against you, you're probably going to lose that voucher. That's going to apply everywhere. The housing authorities who issue the vouchers don't absolutely have to refuse to give another voucher if a tenant is evicted, but almost universally they do. So, when we're dealing with in an eviction situation with somebody who has a Section 8 voucher, we're very careful to try to negotiate some kind of agreement, even if the tenant has to move, where there won't be an eviction judgment entered, because they will lose their Section 8. So another thing that's generally true is that a landlord can't retake possession of leased premises without filing an eviction and getting a judgment that gives them possession. So the landlord can't just come over and say, you haven't paid your rent or your lease is up or whatever, and just start carrying your stuff out. They have to get an eviction judgment in order that allows them to do that. Now, particularly now during COVID, and there's been eviction moratoriums, and landlords, a lot of landlords have been engaging in kind of self-help evictions, where they do go and change the locks on the property when the tenant is at work or at the grocery store, or they will just come over even while the tenant's at home and start setting the tenant's property out of the premises. If that should happen to you or anybody you know, if somebody should ask you about that, they should call the police
immediately. The police are now very good at understanding that a landlord can't just retake possession of the property, that they have a court order, and they will come and they will stop the landlord from removing your property, or tell the landlord to change the locks back or whatever. Now, sometimes if the locks have been changed and the tenant can't get in, the police will say, well, you have the right to be there, so you can just break in. I don't know that I necessarily suggest that, but that would be the time to get an attorney to intervene for you so that you can regain possession of the property. If you lose at an eviction hearing, you may have the right to appeal. It depends on your state law, but you almost certainly will have a right to appeal. But what you should remember about any appeal, whether it's an eviction case or any other case that you have, is that an appeal is to review mistakes that the trial judge made in interpreting the law. It's not based on the idea that, well, I don't like what this judge decided, so I'm going to go present the facts to the Court of Appeals. It's not a rehearing of the facts in a different court. It's saying, you know, the judge interpreted the law wrong. The judge applied the law incorrectly. So that's how appeals work. There's tons of other stuff that we could talk about, but we need to move to the Fair Housing Act. So now the Fair Housing Act is a federal law, so that's going to apply everywhere. Unlike what we were talking about with landlord tenant, this is going to be something that applies throughout the nation. And what the Fair Housing Act does, and it will couple with the Americans with Disabilities Act as well, which provides basically the very similar type remedies. But it prevents discrimination based on race or color, religion, sex, national origin, familial status, or disability. So, you know, we could talk in detail about all those things, but we're not going to, because one, I'm not an expert on fair housing. I'm familiar with it, but I'm not an expert. But we will talk about disability, because I think that is what is of most interest to you all. So the first question is, what is a disability? So that means that they have a mental or physical impairment that limits one or more major life activities. Okay, so that's like, okay, well, what does that mean? What's an impairment then? Well, impairments are things like blindness, hearing impairment, mobility impairment, HIV infection, mental retardation, alcoholism, drug addiction, chronic fatigue, learning disability, head injuries, and mental illness. So any of those kind of things can be impairments. Other things could be an impairment too. It doesn't have to be on that list, but those are the common impairments that the Act lists. Okay, so those are the impairments, but what is a major life activity? Well, those activities include but aren't limited to seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, or working. I think there should be a comma between learning and speaking. So it's learning, speaking, or working. So those are the major life activities. They include those things. And we'll talk about examples in a minute. Now, where it doesn't apply is it does not apply to current users of controlled substances or to traffickers in those in controlled substances, or people who have been convicted of trafficking in controlled substance. And it doesn't apply to people who have been convicted of sex offenses. So those people will not be considered disabled. And it also, the act will not protect anyone if they are a direct threat to others. So somebody might be disabled, say, because of mental illness, but if their mental illness causes them to be violent or act out of control or whatever, the Fair Housing Act may not apply to them. So what do you do if you have a disability, and what does the landlord have to do? So it requires you to ask for a reasonable, you have to ask for it. You can ask for a reasonable accommodation. And that is for them to either change the rules or policies they've got, or their services, or even make modifications to the property when the accommodation is necessary to allow a person who is disabled an equal opportunity to use and enjoy their dwelling, and then any common areas. So common areas would be like if you live in an apartment complex, and the swimming pool would be a common area, or if they have a meeting room or something like that, those would be common areas, and they would have to make it a reasonable accommodation for that. A landlord can't refuse an accommodation that's a modification to the premises if the disabled person is going to pay for it. So if the person is renting a house and it has steps, and they need a ramp to get in the front door, and the tenant says, well, I'll pay to build the ramp, the landlord can't say, no, I think a ramp's tacky, so I don't want a ramp there. They can't refuse that reasonable accommodation where the disabled person is going to pay for it. And so an accommodation is not considered reasonable if it creates an undue financial or administrative burden on the landlord. So if somebody lives on the third floor of an apartment building and has to walk up the steps, and they become, their mobility becomes impaired, the tenant couldn't say, okay, landlord, I need you to install an elevator for $500,000 or $1 million, however much a new elevator would cost, because that would be an unreasonable expense. But a reasonable accommodation would be for the tenant to say, landlord, I'm mobility impaired, and I really can't go up these 3 flights of steps anymore. Could you move me to the first? I would like to move to an apartment on the first floor. That would be a reasonable accommodation, and the landlord would have to do that. But also, again, the accommodation has to be reasonable. The landlord doesn't have to evict somebody to make a vacancy on the first floor. But when that apartment on the first floor becomes vacant, the landlord would would have to give it to the tenant and let them move there. And that situations like that are most often the times that I see tenants asking for reasonable accommodations is to be able to move to a different apartment because of some condition in the apartment they've got that that is impairing, that their disability keeps them from enjoying the apartment. So it's often a relocation issue. And then finally, the accommodation has to be related to the disability. You know, a tenant couldn't, whose mobility was impaired, say, and already lived on the first floor, couldn't ask for reasonable accommodation to be moved into another apartment on the first floor on the other side of the building because they liked the view out of the other apartment better. That would not be requesting a reasonable accommodation. That would just be saying, hey, can I move apartments because I like the view out of the other window better. It's not related to the disability. So if you feel like you've been discriminated against, you can file a complaint, and every state is going to have an organization that deals with that, and it's going to have a name like Fair Housing Council. Like in Kentucky, there is the Lexington Fair Housing Council. They handle fair housing complaints for the entire state. So, you know, if we get a complaint in Jefferson County, we refer them to the Lexington Fair Housing Council, even though Lexington's 90 miles away or whatever. They will do the case here. So it'll have wherever you live, it'll have a name like Fair Housing Council or the Human Rights Commission or something like that. So that would be what you would look for as far as the name. That also applies for any of the kinds of discrimination that we were talking about above. You know, if it's discrimination based on race or religion or things like that, or families with children or whatever, then the Fair Housing Commissions will investigate that. They often send out groups that will test and see if a landlord is favoring one group over another or whatever. So that's who you would be in contact with if you feel like you're being discriminated against. So at this time, it looks like I went a little bit long, but I'll be happy to answer any kind of questions that people have. If you have questions about the CDC moratorium, I'll be happy to try to answer those. I intentionally kind of left that out because I knew we wouldn't have time for anything else if we got into that. So if you got questions about it, I'm happy to try to answer.
Thank you so much, Stewart. That was amazing. I learned so much from your presentation. So I'm grateful for, you know, I know you were saying it's a topic that you were excited about. And then as you initiated the topic, you were like, oh my gosh, there's so much to talk about. So I think you did a great job at communicating the important parts.
Thank you.
You said. So like Stewart said, at this time, we're going to open it up for questions. For those who aren't familiar with the Zoom platform, there's a question and answer section at the bottom of your screen. If you click on that, that's where you can enter your questions for us. It can be a question for Stewart. It can be a question for Diahanna. but we invite you to ask your questions at this time. And just briefly, as we're waiting for questions to come in, I do have Stewart's contact information and I have Diana's contact information, and that will be shared with you in the recording that will be sent 24 to 48, along with the recording, which will be sent to you 24 to 48 hours after this event concludes. Let's see. No questions yet, which is okay. It just means that you explained it really well. Stewart's did a great job.
I'm trying to go to Q&A. It's not allowing me to put a question in.
That's because you're a panelist, Diana, so you won't.
Okay, well, okay. That's fine. I just want to make sure it was working.
No, it's okay. It's working for the participants, but as panelists, we don't do that.
Well, while we wait for questions, I guess I could talk for a minute about the CDC moratorium and some of the things surrounding that. You know, right now there is an order from the Center for Disease Control that has placed a moratorium on evictions for non-payment of rent. Now, it only applies to evictions for non-payment of rent, not other reasons. And what's required of the tenant is to jump through a couple of hoops. They have to use their best efforts to try to come up with the rent, you know, seeking help from community groups or whatever to pay the rent. And then they have to file a declaration with their landlord, which the declarations are available online all over the place. It's easy to find one. I'm sure there's one that that's set up for every state and will apply, or you can use the one that is probably on the CDC website, I guess. And you deliver that to your landlord, and then they cannot evict. The moratorium right now is in effect through June 30th. So we've still got 2 months left. Who knows whether it will be extended again? It's been extended 2 or 3 times. I feel like we're kind of getting near the end, and that there's not necessarily going to be much more continuation of it. Maybe they'll continue to September, and I would be amazed if it was continued after that. But I've been surprised by a lot of things during the.
That's true. We were just talking earlier how COVID surprised us.
The other thing that I would point out to everybody, and you know, I'm surprised that even now everybody doesn't know about it, but the federal government has given the states millions and millions of dollars for rental assistance. So wherever you are, there's probably rental assistance, and like locally, they will pay all back rent, even if it, you know, at this point, you know, some tenants might be 14 or 15 months behind.
Yeah.
They will pay all back rent plus 3 months future rent.
Wow.
So, and, you know, there's similar programs throughout the country. So if anybody listening to this is behind in rent, they need to check to see what their state agency is providing rental assistance, because it should be there and it should be available.
And how do they go about doing that? Do they Google it? I don't know. How do they find
I think you would just probably Google like rental assistance in Utah, rental assistance in South Dakota, and, you know, and that it would show up.
Yeah, awesome. There's another question, and it's how do we get involved as a community to support organizations like the Legal Aid Society? What are things that, you know, the community can do to help those who are struggling?
Well, Well, I mean, one thing would be to contact your local legal service provider and ask them what kind of volunteer opportunities they have. Another thing would be if you have a particular interest, say, in addressing homelessness or preventing homelessness or things like that. There will be agencies that you can volunteer with. Every so when HUD gives money, which goes out to all the states to provide homeless services, shelters and things, every state has to have something called a continuum of care that kind of distributes that money. So you can contact the continuum of care for your area. It's whatever, there are common things that people, that low income people need help with are housing, housing questions, nutrition. I found out a bunch of my neighbors are participating in a food kitchen, and a lot of them are retired, and they go over and they cook food in the day so that Meals on Wheels or whatever can deliver it. Domestic violence, we do a lot of work with victims of domestic violence. So, if that is a concern for your listeners, there are organizations that specifically provide services to victims of domestic violence. So, there are plenty of opportunities to volunteer and reach out and help with people providing those services.
That's great to know. That's great to know. Thank you. I think it's sometimes hard, as you were saying, as it varies state by state, but it's important to get involved where we can for those of us who don't find ourselves in this situation.
Yeah, and I think, some of the things, like every place is going to have homeless shelters and service providers and agencies that provide things like Meals on Wheels and things like that. And it's, that's sometimes also elderly people
Right.
get those meals. It's not necessarily the homeless or whatever, but it's people who are disabled and can't cook or do whatever themselves. So.
Right. Yeah.
So as a financial coach that talk to a lot of people, who would be an ideal client of yours? I mean, if I needed to refer somebody over, what areas of law, and what do you mean by low income? I mean, what is the criteria for using Legal Aid Society?
Okay, so all the legal service organizations in the country are, most of them receive funds from the federal government, from the Legal Services Corporation. So they issue rules on what we can and can't do. And like one of the things we don't do is we don't do criminal cases. We don't do cases where attorneys can normally get a fee. So we wouldn't be doing a slip and fall case because an attorney would do that on a contingency fee basis. So there's people out there that will do that. The basic qualification is that somebody has to live at or below 125% of the poverty guidelines. I can't tell you exactly what that is, and it varies, by the number of people you have in your family. So what I can tell you is that's not a lot of money, but it's at 125% of poverty. There's an exception to that that lets us represent people up to 200% of the federal poverty level. And the exceptions to that are really broad, and that kind of brings in the working poor. But it's things like paying taxes. So anybody that's got even a part-time job is paying taxes. Paying rent or mortgage. So right there, you've caught just about everybody that would be between 125% and 200% of poverty. And then also there's an exception. We can represent anybody aged 60 and older under the Older Americans Act, Title III, regardless of their income.
So if a person had problems with disability, having disability issues, or having to sue for the disability issues, if they're still working for short-term disability, for all those things, or Social Security, trying to get Social Security income, I mean, they can come to a legal aid society. They would have professionals there that could help them with that.
Yeah, we have people that will help apply for Social Security disability or SSI, depending on their previous work history is what you qualify for. But we will have people that do that. Now, at this time, we mostly help people who are looking to get SSI because they don't have a longer work history. If somebody's got a work history where they might, get a higher disability payment, they may go to the private bar on that because Social Security Administration now provides that attorneys can get a fee out of that. Now, we never take the attorney fee on those cases if we get it, but in the private bar, they are more anxious to do those cases than they used to be because they can get a fee and it goes straight to them. It doesn't go to the client first. So they'll take those cases. We're more likely to have SSI.
So it's good to know that people over age, no matter what their income is, over age 60 has access to legal aid society, which is really great because a lot of our patients are over 60, majority of them. So that's good.
Yeah, and that will apply to any of the legal service organizations throughout the country. They have the same regulations that we have. So that'll apply no matter where you live.
Perfect.
Great. Thank you guys so much for this time. And thank you, Stewart, for joining us today again. I loved your presentation. So thank you for that. Thank you for facilitating this. We're going to end with a couple of announcements. So our next meeting will occur on June 1st, 2021, obviously, and it will be at 1 p.m. Eastern, and we'll be talking about clinical trials, how to find and pay for the cost. This is something I didn't know before Diahanna brought up this topic, but they're not always free. So how to find those clinical trials and how to pay for the cost. We will be including the link to sign up for this event in your follow-up email if you're interested. There are other upcoming events that you might be interested in. Wednesday, May 5th at 7 p.m. Eastern is our Fitness for Myeloma chapter. We're going to be talking about the importance of strength training. And Lindley Sweeney, who is our myeloma fitness for myeloma chapter head, she is going to be giving us a demo of strength workouts that we can complete at home. And she'll be including modifications for those of us that need it. And May 6th at 1 p.m. Eastern is our stem cell transplant chapter. Whether you have an inpatient or outpatient procedure, or maybe are just simply considering a stem cell transplant, learn what items you will need during those first 30 days. Thursday, May 6th at 2:30 p.m. Eastern is our Intermountain Myeloma chapter. We're going to be talking about improving the quality of life for myeloma patients in survivorship. The 11th at 6:25 p.m. Pacific time will be our Southern California Myeloma Community Chapter event. Myeloma Crowd by HealthTree founder Jenny Ahlstrom will be joining us for a discussion about her 11+ year journey as a myeloma patient. And it's going to be an interactive Q&A, so you'll be able to communicate with her the questions that you've had and want to ask her. The link for any of these events and even more events that I haven't mentioned today are found at the bottom of this slide, and they will be sent out in the follow-up email as I've discussed. Another thank you to our sponsors, AbbVie, Bristol Myers Squibb, Amgen Oncology, Genentech, Karyopharm Therapeutics, Oncopeptides, Adoptive Biotechnologies, and Takeda Oncology. And thank you for sharing this virtual time with us and growing the myeloma community together. I really appreciate your attendance and your participation, and we'll see you later. Thank you.
Thank you.